Thanks to Michelle and AELA for the invitation to this important event. I am participating from Quito, Ecuador, in South America, and I have prepared the presentation for you on the Ecuadorian case of the rights of nature. As you may know, Ecuador is still is the first country and to date the only country having recognized constitutional rights to nature. The recognition is made by the Constitution, not by legislation nor by jurisprudence, but by Constitution. And this happened 15 years ago in 2008 when the Constitution provided basically the rights of existence, the rights of persistence, and the rights of restoration of nature. And also expressly stated that nature is a new subject of rights or a rights holder. This is the translation of what you will find opening the Constitution of Ecuador. So you can see is rights to nature on integral respects of her existence, maintenance of her vital cycles, as well as the right of restoration if in case of nature's harm. What has happened in between 2008 and today is very interesting, and I would like to present this in two periods. The first period, ranging from 2008 and 2019, it's characterized by a very low legislative content. This is important for you to know. Ecuador follows a civil law tradition in which any constitutional right is usually developed by legislation. This is not the case in the rights of nature. What has happened with the rights of nature is a direct application of the Constitution. Cases have been taken to court, many cases, among other reasons, because this is the effect of the rights of nature being recognized as constitutional rights, as autonomous constitutional rights. So as an outcome of that, you have these new rights given content not by legislation, as it usually happens, but by jurisprudence, and specifically by constitutional jurisprudence. Between 2008 and 2019, one could see the first jurisprudence, the early jurisprudence on the rights of nature, basically focusing on recognition and integration of these new rights into the juridical ratio. Since 2019 and to date, things have evolved significantly, basically because of the work of the Constitutional Court of the country, the Constitutional Court of Ecuador. It is important for you to know before we go into the content of the decisions, it is important for you to know that the Constitutional Court of Ecuador is the highest body of constitutional control, interpretation, and justice. The Constitutional Court of Ecuador has 9 members, all of them experts in constitutional law, in human rights, and in constitutional procedural law. So what they rule is basically following a juridical logic of global constitutional law. The period of 2019 and 2022, it's important because the court decided on topics of social relevance. For example, issues regarding minorities and issues regarding nature. This is very important for you to know. The court paid attention to cases regarding minorities, the constitutional rights of minorities. And in that context, it included nature. The cases that the court has have addressed regarding the rights of nature between 2019 and to date are all complex cases, complicated cases, because these cases refer to the relationship between human rights, such as property, such as labor, such as economic development, with the rights of nature and also sustainable development. And basically what you find in nearly a dozen cases decided by the court already is issues regarding industrial mining projects in biodiversity areas, issues regarding hydropower plants reducing or diverting natural flow of rivers, as well as issues regarding species, the loss of habitat of wildlife in Ecuador. So you can see these are cases that are not easy, considering that Ecuador is a country that bases its economy on natural resource exploitation, namely oil exploitation, and from recent years to date, also industrial mining. In 2022, the Constitutional Court of Ecuador issued or ruled on the very first cases. To date, there are 6 cases. Very important decisions, because they have given content of what we know today as the new rights of nature. So given the time, I'm not going to go into detail of all these cases, but I would like to mention at least 2 of them. Los Cedros case, that you will also probably have heard, is a case regarding the prevention of the extinction of endangered species. And in order to prevent the extinction of endangered species, the court ruled that mining activities are prohibited in the habitat of these species. Okay, I will go a little in the question and answer section, I will go into a little detail on this. But in this case, the court gave priority to the habitat of endangered species over over mining activities. What was the rationale behind this decision? The court decided to apply one of the provisions of the Constitution on the rights of nature that orders the states to prevent the extinction of wildlife, the wildlife that is endangered. So given that provision, the court said, I will rule in favor of wildlife over mining activities. This is something that in the era of environmental rights have never happened. In the era of environmental rights, the decisions will always prevail on the side of economic development. There is in the court have ruled in a similar pattern in several cases, as I have mentioned, and basically what the court has said is that the rights of nature and environmental rights in Ecuador are different. So this is very important. They are not the same. They are not a synonym, but they are different. The rights of nature being autonomous. And they are different for many reasons, but the most important ones are like the right holder is different. In the context of environmental rights, the human being is the rights holder, whereas in the context of the rights of nature, nature herself is the rights holder. Regarding the scope, there is also a difference. In the world of environmental rights, the scope is to protect something, to protect the environment, because it is useful to the human being. Whereas in the context of the rights of nature is to respect someone, to respect a new subject of right. In this case, nature herself. And this is not semantics only. This has very juridical important consequences. Basically, the consequence is that the standards on the rights of nature are different than the standards of environmental rights. An example that I will give using the same case of Los Cedros is that in the context of environmental rights, the state authorized a mining activity in the habitat of endangered species. Because according to the environmental rights standard, the mining activity was more important than the protection of the habitat of these species. But in the context of the rights of nature, the authorization was actually in violation of the constitutional rights of nature, because by authorizing this activity, it will create a risk upon a species that is already in danger of extinction. So you see the difference. The standard is always more is harder, is higher. The standard on the rights of nature is higher than the standard on environmental rights. This leads to the last difference. The scope of environmental rights is on the side of environmental law, okay? Or I shall say on the side of environmental legislation, which in countries like Ecuador is known for being weak. This is basically administrative law. This is basically regulations, authorizations, permits, environmental licenses that not always make sure that environmental protection is met. That's unfortunate, but it's the truth. Whereas the rights of nature are put by the court, are located by the court in the context of constitutional law. That in countries like Ecuador is very strong, is the strongest of all. The rights, what the court have also said, and this is beginning to my conclusion of the talk, is that the rights of nature are constitutional rights of equal significance than other constitutional rights. So this is a very important concept. Basically, what the jurisprudence is saying is that whenever deciding a case where the rights of nature are under review, judges have to take nature into consideration in equal consideration than the rights of property, than the rights of development, and any other constitutional rights. A second idea is that the duty of the state is extended to safeguard nature, not only to safeguard human rights, but also to safeguard the rights of nature. As we have spoken, and this is very important, I would like to emphasize more if we have time on the Q&A question. Definitely, the main contribution in Ecuador of the rights of nature is that it has set higher standards than environmental protection standards. And this is a question for a doctoral thesis. Ron is the rights of nature is actually going beyond the paradigm of sustainable development. At least if you put that paradigm into practice. And this is big words, because sustainable development standards are also very important. But the rights of nature, in certain cases, provides the platform to go even beyond those standards. Because nature, again, is not an object to protect, but a subject to respect, a new rights holder with all that means in legal matters. So the rights of nature are autonomous from environmental rights, but it's important also to emphasize that they complement each other. They are strong because they complement each other. They not exclude. them from other rights. Also important to note is that in order to apply the rights of nature, the courts have to emphasize on the role of not only law, but also science and engineering. All these cases regarding hydropower plants, regarding wildlife species, regarding the habitat, have required the opinion of experts in biology and engineering. And the court has opened its doors to listen to these experts. So you can see a real dialogue put into place in these court cases. And of course, and this is something that is important, maybe not by it might not be as interesting as the other topics, but you could see a dialogue between courts in Latin America, because in Latin America, the rights of nature are emerging certainly with very strongly. I will just mention this because this is a topic for another talk, but the Constitutional Court in 2022 also concluded that animal rights and non-human animal rights fall also under the umbrella of the constitutional rights of nature. And in 2022, the court ruled on a case that decided that the rights of certain animals are to be included within the context of the rights of nature. This is a case regarding a woolly monkey, a primate. There are pending cases that the court is yet to rule, specifically 4 pending cases on hydropower plants and mining projects. So the future is interesting in Ecuador because the introduction of the rights of nature into the juridical order of Ecuador has provided a scenario that is not environmental law scenario anymore, but a constitutional law scenario. And of course, is a contentious scenario because not everybody is in agreement with the rights of nature. But that is providing a very high level of constitutional law debate whenever addressing the rights of nature. Thank you very much. So let me know if you have any questions. But first of all, I would like to ask if my talk was understandable. English is not my first language, so let me know if it was clear.
It was excellent. Thank you, Hugo. I'm always in deep admiration for anyone who can work in several languages, given that I'm gifted only in one language, and at that, I'm not even sure about gifted. But no, thank you, Hugo. And some great points in there about the complexity of all of the cases going on in Ecuador, balancing human rights, rights of nature, and that endless urge for development. So that was very helpful. Just a couple of questions from me, and I guess I'd like to stress that for those listening to this recording or watching us live, if you have important questions for Hugo, please send them through to AELA, and we can collate them and send them on to Hugo, and I'm sure that he will answer them if he has time, which is wonderful. So Hugo, there's a couple of points that you talked about that I would love you to share a bit more about. In a way, you've sort of flagged that the rights of nature in Ecuador have actually evolved, and now that they're new constitutional rights equal to all other constitutional issues. So how is that different to how other places continue to look at rights of nature, do you think?
It's very different because, at least in Latin America, there is a trend, a current that is suggesting for the rights of nature to be included in the context of environmental law. That I will say that's the majority of the countries, that they realize that environmental law is somehow not fully effective when it comes to protecting nature. So they are suggesting for nature to be included in the context of environmental law. However, in Ecuador, that is not the case, because nature is now a new subject of rights. Nature and the constitutional law of nature is taking another avenue, a different avenue, an avenue that is characterized by a strong response from judges, from legislation and from procedural matters as well. So definitely in the case of Ecuador, I guess is unique in that aspect, because as you could see, most of the decisions of the judges regarding the rights of recognizing rights to nature have meant that they have to, for example, declare environmental law provisions as contrary to the Constitution on the rights of nature. See, the court has, in several cases, annullated or revoked environmental permits because they are too low in standards to protect nature. So this is clearly showing that the case of Ecuador is unique in the way that the rights of nature are falling out of environmental law because environmental legislation has proven to be very weak when it comes to protecting nature.
No, it's fascinating, and something that's I'm sure will be pondered by many of us who wish we could also focus on rights of nature or laws of obligation or whatever is culturally appropriate in our constitutions in different places. The other question I had is, before I go to my third question about the influence of Indigenous law, you mentioned that the rights of nature in the Constitution in Ecuador is encouraging dialogue between courts. What did you mean by that? Did you mean the courts in Ecuador or across different countries in Latin America?
In both within and overseas. See, in Latin America, it is not uncommon for the courts to take a look of what each court is doing. So, to be honest, the rights of nature jurisprudence began not in Ecuador, but in Colombia, with the famous 2016 Atrato River decision. So after that, all the courts from all the countries began thinking about or taking a look of what is this rights of nature trend. And then you see the Argentinian court also taking the lead. The Mexican court, all these courts are very important. They very enjoy high level of prestige in the judiciary in Latin America. So you can actually see that in some decisions of the Ecuadorian Constitutional Court that basically the message is, of course, if other courts that do not have the rights of nature in their constitutions are thinking about nature in this specific way, then we should also not only follow that path, but also take the lead, because we are responsible, since we are the only country recognizing rights to nature in the Constitution. We are also responsible of saying to the world, what are these rights of nature? And my opinion, my assessment is that the Constitutional Court of Ecuador has done a very responsible job in doing that, in giving content, in actually telling you what are these rights and how different from the other rights are the new rights. If you take a look of the decisions, they are decisions that can be read anywhere by anyone which has a minimum knowledge of constitutional law. This is not environmental law decisions. This is basically constitutional law and procedural constitutional law put into practice into these new specific rights.
That's fascinating. Thank you. And there are often a lot of comments and questions about the interaction between Indigenous philosophies and law and the rights of nature in Ecuadorian law. Can you talk a little bit about the early influences of Indigenous thinkers and to what extent is Ecuador influenced by Indigenous law?
Very important question. Indeed, the rights of nature have a very high influence from the indigenous legal tradition, which is in Ecuador coexists with the civil law tradition. However, in the cases that the court has ruled, the tradition that prevails is the civil law tradition. And because all these cases have to do with environmental permits, with permits regarding water. What I'm trying to say is basically all these cases are the origin of these cases is not indigenous legal tradition, but administrative law, as known anywhere. So in that regard, the role of indigenous legal system is highly recognized as catalyst of the new rights of nature. With the concept of Pachamama, with the concept of summa causae, that it goes beyond the sustainable development, is well-being. But once put into practice, the cases have taken the road of civil law tradition. And this is important for me to say, because this means that the rights of nature can be applied in any legal tradition. You don't need, it's not an exclusive from indigenous legal traditions, but you can apply it in any country that follows, like Ecuador, the civil law tradition, or even the common law tradition, because as you can see, the rights of nature have evolved in Ecuador, not by legislation, but by jurisprudence.
That's fascinating. Thank you, Hugo. We're almost out of time, but don't worry, AELA will be inviting you to come back for a much longer webinar, I think, in the next series that we have over the coming 12 months. But just to wrap up, what do you think is the future for rights of nature in Ecuador? Do you think it has the power to get stronger, or will it constantly be a battle for the environmental protection that many of us want, or the respect and protection that we want?
The future is already here, and it's characterized by battle. Michelle, the rights of nature in Ecuador have gone from 0 to 100 in only 15 years. They have already shown that they can be very, very powerful, and many are not content with this, because in the past, basically, if you got an environmental license, you can do anything. But now the court has said that's not the way with the rights of nature. You have to get very serious whenever addressing the rights of nature. So, of course, on the side of industries that have been affected by these higher standards, the reaction is, from the last 2 years, is very, very strong. And I have to say, the reaction is also based upon a very good constitutional jurists, people with very high knowledge and prestige in Ecuador. So what you see right now in Ecuador is basically a contentious scenario, trying to weak or to block the evolution of the rights of nature. Of course, on the side of the rights of nature, there is also a good legal profile, and what I can see in the following years is very strong litigation, but of very high level as well. This is also good, because it's good for the rights of nature to be contending, to be litigating in a scenario that is marked by very high thinking, very high jurists. At least I see that as good, because whatever the outcome will be, it will be of top quality. And also because these cases are decided not on first level courts or on appeal courts, but on the top court of the country. That's also very good. As in contrast with, if these rights were to evolve in legislation, that won't, in my opinion, that won't be as good, because legislative power is basically political scenario, and I must say very low political scenario of low quality. Whereas in the rights of nature are right now in a very the highest juridical scenario, not only for the judges, but also for the lawyers who are fighting in favor and against the rights of nature.
That's a really excellent point. Look, Hugo, we're just about out of time, so I just want to say a huge thank you to you. I know you're very busy and you're now speaking to us in your evening. Thanks for joining us, for your insights into the work that you've been doing and watching and working in for 15 years or more. Yeah, we look forward to having you back for a longer webinar, perhaps analysing some of the more recent developments in the constitutional courts in Ecuador. So, Hugo, thank you so much for your time.
You're welcome, and thank you for the invitation, and good luck in the event.